Hello, everyone, and welcome to the Bar Association of the District of Columbia and the Metropolitan Washington Employment Lawyers Association's winter webinar, The Sprint to the Finish Line, Creating Maximum Impact in the 90 Days Before Trial. I'm Scott Oswald. I am MWELA's Bench Bar Committee Chair and your moderator for today's program. Before we begin, Rawle Andrews, President of the Bar Association for the District of Columbia, has joined us, and he is going to tell us a little bit about what BADC does and some of the value of membership. Rawle?
Thank you, Scott. Happy New Year to one and all, to our esteemed panelists. On behalf of the board and the members of the Bar Association of the District of Columbia, it is our privilege to be joining MWELA in this sprint to the finish line. A lot of people talk about the importance of the first 90 days, but I do believe it's that critical period in the last 90 days before trial when really a lot of action happens that's going to drive the outcomes of our work. So it's a privilege for us to be here. Also a privilege to have as part of our gathering from the BADC, my president-elect, Matt Nace, who is one of our star trial lawyers in the bar. As many of you know, and all of you should know, since May of 1871, right there at the corner of 6th Street and Pennsylvania Avenue Northwest, the BADC was founded. It was the first bar association in the district. It is the longest continually operating bar association in the district and the third oldest bar association in the United States. We have 3 sections, a young lawyers section, an intellectual property section, and a bankruptcy section, as well as 20 practice area committees. Notably, Scott, there's never a separate fee. Once you become a member of the BADC, you're eligible to join and in some instances lead as appropriate any of those sections or those 20 practice area committees. Matt Nace tells me that the chairmanship or the chairwomanship of the labor and employment section is vacant. And so if you're looking for an opportunity to serve and you've already served in MWELA, or you're waiting for your chance to get off the bench and you want to put some background to your LinkedIn pedigree, give us a call, reach out to us, and let's see whether or not this might be an appropriate opportunity for you. And then quickly coming down the pike, as part of our Black History Month programming, the BADC will be hosting ABA President Deborah Enox Ross in a program on February 21st at Reed Smith regarding the state of the legal profession. We'll get more information, Scott, to you and your team as well as others, so you know how to participate. That's a complimentary program, but we do need registration to get there. Now that COVID has put us in an endemic, we will be taking our first foreign trip, our intercultural exchange or annual convention to Rome, May 1 to May 7. More information will be coming out next week about how those folks who want to go to Rome with us and talk to some lawyers across the pond, visit the Vatican. We're hoping to meet with the chief conciliary of the Pope while we're there, among others. So a great opportunity. You do not have to be a BADC member to join that, but we hope it'll be an inducement for you to join. And then finally, many of you are aware that DC Bar past president Shirley Higuchi was transformative in creating a pilgrimage to Heart Mountain, Wyoming. It was one of the internment camps during World War II where her parents met. And we are taking a pilgrimage during July 21 through 23 to the Heart Mountain event. We'll be dealing with the Wyoming Bar Association, among other folks, while we're out there. Again, no need to be a member of the BADC, but members get more. So if you are a member of the BADC, there can be some additional considerations extended on your behalf. So Scott, again, thank you so much for giving us an opportunity to partner. We look at this as a relationship, not a transaction, and we look forward to more to come across our couple of organizations. So again, Happy New Year, welcome, and thank you.
And Rawle, thank you. And now to our participants in today's roundtable, the Honorable Anthony Epstein is a DC Superior Court Civil Division presiding judge. Judge Epstein is a member of the court's Ethics Committee, the Superior Court Rules Committee, and the Advisory Committee on Civil Rules. Alfred Irving Jr. is a DC Superior Court Associate Judge. Judge Irving has served as a DC Superior Court Judge since 2008. The Honorable Gregory Mize is a DC Superior Court Senior Judge. Judge Mize is a Judicial Fellow at the National Center for the State Courts, undertaking projects involving judicial education, civil justice reform, jury trial management, and citizen access to justice. John Remy is a principal at the law firm of Jackson Lewis, where he represents management in employment disputes. John has significant jury trial experience in 4 states. Devin Wrigley is a partner at Bernabei and Kabat, where she represents employees in employment disputes. Devin has recent successful jury trial experience in DC Superior Court. I'll take at least some of your questions throughout today's program. Just use the Q&A button located at the bottom of your Zoom screen. Judge Epstein, good afternoon. I'd like to begin with you, and let's talk about that first kind of marker in that 90 days in the run-up to trial, the Rule 16 conference. And Rule 16 C2A requires the parties to meet and confer to formulate and simplify the issues for trial. And I know as trial lawyers, it scares us, but tell us why it's a good idea for a party to agree to eliminate maybe some claims or defenses.
I think the main reason is that it's going to help the jury understand what's really at issue and what's not at issue. I know I've spoken to a lot of juries after trials, and they really appreciate it when lawyers are focused and they don't have to listen to a lot of extraneous peripheral evidence. I think the Rule 16 mechanism is the time for the parties to get serious about what really needs to be litigated at trial, to pair off the peripheral issues from the plaintiff. It means different labels on what is really one theory. It means for the defense to abandon some of the boilerplate defenses that defense lawyers like to include in their answers, and figure out what the case is really about, what witnesses need to be called, and what facts are truly in dispute.
So you describe it as really providing a simple, clear explanation of their case. I mean, that sounds kind of straightforward, but in practice, it's tough. What advice do you have to lawyers in kind of thinking about slimming down their case and focusing on what really matters?
I mean, some lawyers think that, maybe even at the, when you file the complaint, you ought to be thinking about your closing argument. One tool that I think some lawyers use, and I think it can be effective, is to figure out, what do I need to be able to say in my closing argument? What evidence do I need to be able to point to in my closing argument to satisfy the jury that I've carried my burden of proof, or that the other side has not? Do I really need this witness? I mean, I think it's prudent to include witnesses that you may well not call in the statement, but I know at least lawyers in my courtroom got used to me asking them, which witnesses are likely to be called. I don't think judges play gotcha with lawyers. They understand that things happen during trial. You have to switch gears. But one thing I think I can speak for the other judges, at least on this panel. We need to give jurors a realistic estimate of how long trials are going to last. And, we need, it's hard to predict. I think we all get that, but lawyers need, I think the pretrial conference process is the time for lawyers really to kind of get serious and separate the wheat from the chaff.
Thank you. Judge Irving, I want to bring you in at this point. Let's talk about stipulating to undisputed facts when we can. Why is this, from your perspective, why is this important to do? in the Rule 16 statement and the conference in the run-up to trial?
Judge Epstein hinted, it fine-tunes the presentation to the jury. If there are aspects of the case the parties can stipulate to, it allows for a clearer, fine-tuned, more efficient presentation. You end up not wasting time, wasting the jury's time, and you're moving the case forward to its right conclusion.
So, Judge Epstein, one of the things that I get sometimes questions is, okay, so we've stipulated to some facts. How are these articulated to the jurors at trial? Give us a window on how that works.
I, for one, am flexible. I mean, whatever makes the most sense, given the nature of the stipulation. Is the stipulation really for the benefit of one side much more than the other? Is it something, that's important to both sides' case? A lot of times, lawyers will say, at some point, usually in the plaintiff's case, sometimes it's after the plaintiff rests and before the defense starts its case. They'll say, we want to present some stipulations. The judge will give the standard instruction that the juror should accept stipulated facts as true and that no additional evidence is needed to prove them. I tend to push back about reading stipulations myself because they don't come from me, they come from the lawyers, and I don't think that's really the judge's responsibility. But if both sides agree, and it makes sense, I'm willing to do it.
Judge Irving, you're pretty flexible with lawyers if they come to you with a joint proposal on how to get those facts before the jury. Do I have that right?
Yes, it's their case. They've lived with it much longer than I have. And I prefer not to stand in the way of how they intend to litigate the case. My job really is to just call the balls and strikes and make certain that we're moving the case along to its submission to the jury.
Thank you. Judge Mize, I'd like to bring you in at this point and turn to the sources from which our potential jurors are identified in DC Superior Court. To set the stage for us, what are the predominant sources for drawing citizens to the courtroom for jury selection, really across the country?
Our research at the National Center for Jury Studies has shown that the predominant source lists around the country for many, many years have been voter registration and or driver license lists. And I think the growing trend is to expand those sources because huge segments of our population don't vote and huge sections of our population don't drive. And so it is recommended in the legal academy and among many court systems that the source list be expanded to catch more and more citizens so that you have what we call a representative jury, that the veneer, what is happening in the jury assembly room every morning, looks very similar to the community outside the courthouse. And so the District of Columbia, I'm proud to say, is really quite on the forefront of having a wide assortment of source lists besides voter and driver sources. The court has access to, with the help of Department of Finance and Revenue, the income tax rolls, and with the help of other government agencies, public assistance rolls, and with the help of the federal government, newly naturalized citizen lists. So there are 5 sources, and this is the gold standard that the ABA and its principles for juries and jury trials has promulgated for over 15 years. Our neighboring court across the street used to be in sync and use the same source list, but unfortunately for many years, they only use voter lists, driver lists, and income tax rolls. So public assistance and naturalized citizen lists are not used. I asked the jury administrator why that is so, and she said, well, when I took this job, that's the way it was. And the federal statute, the Jury Service and Selection Act of 1968, that is really an anachronism, because it requires in federal courts that only the voter registration lists be used. And there have been efforts over the years to get Congress to focus on that and expand what the statute says. So it's now left up to individual district courts, and maybe some circuits dictate what all U.S. district courts in that circuit must do. So there's discretion at the trial court level to expand beyond the voter registration lists.
So what I'm hearing from you is that the jury that I might be before in federal district court may be drawn from a very different pool of people than in our superior court. Do I have that right?
Well, I wouldn't say very different, but we could be, it's evident that in U.S. district court, folks who are getting public assistance, be it workers' compensation or TANF benefits, they are not summoned. And I think that makes for a loss in terms of what the veneer looks like.
Thank you. John, I want to bring you in at this point to talk a little bit about meeting and conferring with opposing counsel. And you work especially hard to foster a good relationship with opposing counsel as the case approaches trial. Why?
Well, I guess really two reasons. Number one, I think it's a more pleasant and professional way to practice law. I think it does our profession well, right? And I take that seriously. But the other one is I think it's better for the client. You know, I don't believe that a lot of, and I'm sure that I would imagine the judges appreciate this too, right? A lot of unnecessary motions practice and uncooperative behavior is really going to lead to a better result. Not only is it more expensive, of course, for the client, but I just don't believe it leads to a better result. Now, that doesn't mean you agree to things that are not in your client's interest just because you want to get along, right? There are times you have to disagree, and the court's got to make a decision about that disagreement, or and the opposing counsel's not happy about it. They right, and so that's part of the deal. But I do believe that the ability to get along is really in everyone's interests.
What are the most important topics, John, in your meet and confers with opposing counsel that you want to resolve, if you can, in the 90 days before trial?
Yeah, right. In the 90 days before trial, I think the most important one is the agreement on the exhibits that no one's going to object to, right? Not necessarily joint exhibits, but exhibits that everyone's going to allow in, and that allows you to plan your case. I'm a big believer that I almost don't want to mention, much less rely on, any document or other exhibit that I don't know for sure is coming into the case. And so I never want to be in a situation where I tell the jury in an opening, they're going to see this or they're going to see that, and then that doesn't materialize. That's a terrible situation to be in. So getting agreement on those exhibits, not only does it streamline the trial, fewer objections and sidebars and jury leaving the room so you can argue, and researching at night over an evidentiary issue, all the things that make trials so long and unpleasant, and distract from the story, right? And detract from the ultimate outcome. So that's what I focus on, is the exhibits.
Judge Epstein, should the parties, where possible, come to some understanding about agreed exhibits? Do you agree with John Remy?
I do agree with him. I think it for the same reasons he said. I think it's a big advantage for the lawyers to know what's going to be in there. I'm happy to say I don't think in a civil trial I've ever had either side need to call a records custodian. Those kinds of things get stipulated to. And I would add, I think jurors appreciate it when their time isn't wasted. And I would add to Mr. Remy's list of reasons why lawyers should get along. I think jurors figure out quickly which lawyers are kind of snarky and unnecessarily combative, and they don't really like it.
Judge Irving, should, when we, let's say, talk about exhibits and submit them to the court, how should they be identified? By number, by letter? How does that work?
Well, the rule requires them to be, typically they're numbered. And the rule requires them to be compiled in a way that the parties and the judge can easily refer to them and address them to the extent that there are any disputes about them. But the documents typically come in with a post-it or a stamp affixed, usually a number.
So if the parties have agreed, let's say, Judge Irving, to an agreed upon set of exhibits, maybe it's because both sides want that exhibit, so it's a joint exhibit. Should there be a separate exhibit book or exhibit list that the parties put forward?
Well, there should be a notebook, one for the courtroom clerk, one for the judge, one for the witness, and the courtroom clerk should receive a summary of the exhibit so that she can follow along in the trial, establishing which ones have been admitted and which ones were not admitted. So notebooks are, in essence, provided for in Rule 16.
Thank you. Devin, I want to bring you in at this point, and let's talk about focus groups for a moment. You conducted a focus group in your run-up to your recent trial in DC Superior Court. Tell us what you learned.
Yeah, so this was a trial that involved a denial of tenure. It was an age discrimination and breach of contract case. So that was the framework we were dealing with. And we did a focus group a few months out before the trial, and that was incredibly helpful as we were trying to hone in and shape the main themes of the case that we wanted to convey to the jury. And the way that we structured it was we brought in a group of individuals. We tried to find as diverse backgrounds as we could, and we went through different pieces of information about the case with them bit by bit, and we started to give them a little bit more context with each round of information that we gave them. But we kept pausing to get their takes on certain pieces of information and exhibits as we went along. And for the exhibits, we gave the group members 2 different colored highlighters, and we asked them to highlight parts of the documents that they thought were helpful to our clients' claims in one color, to the claims as we'd explained them, and then things that they felt cut against our clients' claims in another color based on some of the defenses that we'd explained to them. So that helped us really decide which documents or parts of documents that we wanted to focus on during the trial, and maybe some that we wanted to downplay a little bit more. And the group also gave some really interesting feedback on some of the broader issues involved in the case. One thing we wanted to ask them about was how they felt about the fact that the university provost, who was the main decision maker at issue, was older than our client when this was an age case. We all know the law says a person in a protected class can discriminate against another person in that same class, but that may not be obvious to the average juror. So we were pleasantly surprised that none of the group members felt that the provost's age was a persuasive defense. And we realized we didn't need to give too much lip service to that issue at trial. And then one other big thing that we wanted to ask them about was a line in one of our clients' pre-tenure reviews. A big defense for the university was that they claimed our client had been on notice that she needed to complete this 3rd book project if she wanted to get tenure. And we argued that her prior reviews said quite the opposite. She'd had already a sufficient number of publications, and that this last book was, quote, icing on the cake. That's the phrase that one of her reviewers had used. And as the lawyers who'd been working on this case for years, we were all convinced that icing on the cake means nice, but not necessary. But some of the focus group members actually had a different take, and some of them felt that the icing is required for a cake, so that meant the book was required for tenure. And that helped us sort of realize that we needed to make this point a little more strongly than we probably thought beforehand as we were shaping the case, and then particularly in our opening and closing arguments, because we knew that this phrase had multiple different interpretations, and we felt ours was the correct one, but the writer of the document was actually deceased by that point, so he could not testify to that. So that was very helpful for us. Those were just a few key takeaways, but I think focus groups can be incredibly helpful in the lead up to trial and trying to shape the themes you want to get across to the jury.
So what I'm hearing from you is that not only did it help you to shape your themes, but it also helped to identify what documents maybe were the most important that you wanted to emphasize to your jurors. Is that right?
That's exactly right. And not only just the documents themselves, but maybe parts of the documents that we wanted to highlight a little bit more during the examinations, and some that we needed to be a little more wary of, perhaps that we didn't think were as supportive of the university's case as the focus group felt. So yes, it certainly helped us narrow down the documents and pinpoint which ones we wanted to rely most heavily on.
Devin, thank you. Let's turn to the presentment of interrogatories, in particular the answers to interrogatories to jurors. Judge Epstein, how are answers to interrogatories best presented to jurors at trial?
Well, one way to get them in is by stipulation. If, depending on who signed the answers to the interrogatories and how they played out, it may become a stipulation. I think, in my experience, I mostly see them come in as cross-examination, essentially as impeachment. If the person who signed the interrogatories testifies differently at trial, they're going to be impeached with their interrogatory answers.
Juror note-taking. How do you handle juror note-taking? Are jurors permitted to take notes during the trial, Judge Epstein?
Yes. As far as I know, every single judge in our court allows note-taking. I think all of us provide paper and pencils or pens to jurors. We explain to them that they can take their notes to the jury room. There's a standard instruction that the jurors the recollection of the jurors who don't take notes controls, and they shouldn't treat note-taking jurors as court reporters. But most judges take notes. It can be very helpful. Lawyers take notes, and especially in longer trials, it's a helpful way to keep track of things. So we don't permit. I would say we almost encourage jurors to take notes. We certainly facilitate their ability to do so.
Judge Irving?
I agree. I allow notebooks, and they're typically presented to the jurors once they are seated. And we instruct them similarly that note-taking is permitted. But if they wish not to take notes, that's acceptable as well.
Thank you. Judge Epstein, let's talk about juror questions. If the parties agree, will you allow jurors to ask questions of witnesses in the trial, during the trial?
Yes. When I started off, it was in criminal, I actually pushed, I kind of made it standard that I would allow questions. There's a standard instruction on questions by jurors. The lawyers mostly hated it, and jurors very, very seldom took advantage of it. I had one civil trial last year where one of the jurors asked if they could ask a question, and the lawyers went along with it. There was one question which I don't think kind of mattered that much in the overall scheme of things, and no more questions during the rest of the trial. But it's certainly an option. I'd really thought it would help promote juror engagement, and that I thought lawyers would appreciate it because we give them insight into at least how some of the jurors were thinking and what they were focused on. But it's essentially turned out to be a non-issue.
Thank you. John, I want to bring you back in at this point. Let's talk about witness order for a moment. What's your general approach to witness order in your case in chief?
Yeah, so in a defending an employment case, it's all about the decision maker, right? The person who made that final decision, or sometimes, more than one person made that final decision. So the question is, how do you structure your witnesses to support like that person? And so typically speaking, that doesn't mean they go first, right? And it doesn't mean they go last. They go somewhere in the middle, and you build literally support around that. So somebody who, you also need to build context. And a lot of this, of course, depends on what happened in the plaintiff's case, but what does the company do? Why is, kind of start off with the company does this very broad thing, and then somebody that builds it down to this plaintiff's position and why take a termination case, right? Your typical case, why the plaintiff's role was important, and somebody in that role who wasn't behaving appropriately or doing their job, how that fits in the entire scheme of the company and how that's detrimental. And then you have to have someone who will build the credibility of the decision maker, someone who suffered as a result of, these or suffered is a little bit of a strong word, but was impacted by the plaintiff's conduct or the inability of a certain department to get something done, and who tried to help the plaintiff, right? Like through this, and then comes the decision maker, and then you have to support them on the backside, right? Then you have to confirm the things they said. So it's this sort of, crescendo with the decision. And this all gets, of course, thrown out the window when the plaintiff's counsel calls your witnesses in their case in any particular order. And, the saying is, if you have the playbook memorized, you can call audibles, right? And so that's why just preparation is the answer to all of that.
Devin, in your case in DC Superior Court, you called your client first. Tell us why.
I think calling the plaintiff first can be a very good option for a couple of reasons. If you think that your plaintiff will present well to the jury, I think in a case with particularly complicated facts, it helps if you are in the driver's seat and can put your client up first to give the full chronology of what happened and explain that straight off the bat to the jury, and that they're starting to identify with her right away. I know some folks in the plaintiff's camp have suggested putting up the decision maker first, so that you can kind of see the bad guy up front and get a visual on that too. And I think that can work in certain circumstances. But I think particularly in a case like we had with very complicated tenure processes that we had to explain to the jury, it helped to be able to give that narrative right off the bat from our client.
And she had kind of the best perspective on really what happened to her and how to do that.
Exactly. So we went through the facts with her, and then at the end of her testimony, we asked her a little bit more about how everything had impacted her and her emotional distress. So it was the narrative followed by how she felt and how that affected her. And it seemed to be effective with the jury.
Thank you. John, you believe that sometimes it's the best outcome for defense counsel to hear the defense side during the plaintiff's case. Tell us more about this.
Yeah, so it's almost like if you want to call the defense witnesses in your case, right? All right, like that's what you're going to get. One of the main advantages of being the plaintiff, I feel, the big disadvantage being the defendant, is that we go second. And, and you could spend 2 or 3 days just being everything in the plaintiff's case, and the defendant doesn't really get to do much except on cross, right? So if there's an opportunity to tell our story in the middle of the plaintiff's case, we're almost always going to take that opportunity, and oftentimes we will agree with the court that, when we are crossing, so to speak, our own witness, we can go beyond the scope of the direct, but then we're not going to call the witness in our case unless something unusual happens, right? We're going to get this witness done so the witness can leave, kind of thing, right? And that's efficient, and most of the time everybody agrees to that, and so we're just going to put our case in, like right then and there, and I think that's a major I understand why plaintiff's counsel want to call defense witnesses. I get it. But if we can get, all the bad things about the plaintiff in the middle of the time where it's supposed to be all good about them, we're going to do that.
So you ideally, John, identify your decision maker to be your corporate rep sitting at counsel table. Why do you do that? Well,
We do that. So the jury gets to know that person. I had a trial one time, and the decision maker was sitting next to me, and she, we were thoughtful about everything she did during the whole trial, right? That when other women came in to testify, they handed their purse to her, right? Or their jacket to her. And eye contact with the jury, all these things, right? And then when we were talking to the jurors afterwards, and she was on the stand for maybe 2 hours, right? Maybe 3 hours total, half a day. And we were talking to the jurors afterwards. These two women on the jury said to her, "Jen, I feel like I know you." Right? And what are the odds of them being like, "Oh, and we think that you're a racist or something," right? Like in that context, that's a pretty damning thing to, a lot of these trials, if you're going to find for the plaintiff, you've got to find something pretty damning against the decision maker. And so the more the jury gets to know that person and see them as a real person and their little interactions throughout the day, throughout the weeks, I think that's a major advantage for the defendant.
John, your goal at trial is to show the plaintiff is either unreasonable or untrustworthy, or both. How do you do that?
Well, those are two different things, right? Unreasonable would be, the best defense, I think, for an employer on let's say termination case, right, which is your typical case, is what else are we supposed to do, right? We gave this person all these guys. We wanted them to be successful. We wanted them to just do these simple things, and they could have kept working here. When you can say to the jury, if they had just done this, they'd still be working there today. But they were unreasonable in their behavior, their approach. I think that this is not really focused on the elements of the claim, right? It's about a jury that's going to say, kind of, who caused this mess? Who brought us here? So showing that they could have had their job, they could have gotten along, that we were the reasonable side. Everyone was just trying to get them to do certain things that anybody would expect at work. And then the untrustworthy piece, of course, is, often through impeachment, right? And the key there is, do you hunt for impeachment, right? Meaning, do you let them or even encourage them to lie if you've got them? Right. So the classic example, right, is, you've got an exhibit and you're on cross or you're calling them their case. So you could show them that document and then ask the witness their opinion on it or whether it's true or not. Right. Or you could ask them first, knowing that they're very likely going to say something consistent with that document or hoping they do. And then you impeach them with it. So one is, if you do it the second way, kind of breaks the narrative a little bit, and it's not a clear story, right? Because you're impeaching somebody in the middle of their testimony, and the jury's got to pick up on that. It's a little messier. But if the jury does catch it and it's worth impeaching on it, that's a major, I think, win for the defense.
John, in your opinion, why are discrimination cases harder to prove to a jury than retaliation cases?
Well, it's that point I sort of mentioned a little bit earlier. The reason why we have the decision maker at table is because that is a damning find, right, against the decision maker, that they are, they are a racist or a misogynist or whatever it is in that case. That's and they're on the stand for 3 or 4 hours, and you're gonna make that sort of conclusion about them. That's a hard thing. I think that's a big lift for plaintiff's counsel, right? On the other hand, it's not a big lift if to say, well, you're the kind of supervisor that doesn't like it when somebody complains and makes your life harder. Right. I think everybody sitting on that jury understands that. And so, and now could some retaliation cases, be difficult because they all have that sort of damning quality to them, depending on what happened next? Yeah. But I think the general notion that people don't like people who complain, I don't think the plaintiff's counsel has to sell that very hard with the jury.
John, thank you. Let's turn to video deposition excerpts and remote testimony. Judge Epstein, how should deposition excerpts that a party wishes to show to jurors be handled among counsel in the run-up to trial?
I think each side should identify the specific excerpts that they want to show. If there's a way to, resolve any objections. Sometimes there's an issue about the rule of completeness. Then, one side wants to play this section. The other side says, well, if you want to play that, then you've got to play, the 12 questions afterwards or the 5 questions before. I think I really try to resolve those issues before trials so we don't have delays when jurors are sitting around, waiting for that to be resolved or for the videotape to be edited so the correct portions can be played.
And if a party wishes to have a witness appear remotely, will you entertain that motion, Judge Epstein?
I'm happy to say that we just amended Rule 43 to make it easier for that to happen. I think one of the lessons of the pandemic, when we held countless bench trials remotely, is that it can be very effective. It used to be that our rule, like the federal rule, required a showing of compelling circumstances to allow a witness to testify remotely. We eliminated the compelling circumstances requirement. I think if both sides agree that a witness can testify remotely, and a lot of times the other side is happy to agree because they think the witness will be less effective testifying remotely than in person. If both sides agree, that resolves it. But even if one side objects, judges have more discretion now to permit a witness to testify remotely.
So, John, let's talk about from your perspective, under what circumstances would you agree if plaintiff's counsel wanted to have a witness testify via Zoom? Let's take a fact witness first.
Well, it's, I don't want to sound result oriented about it, right? But if the witness is not going to testify at all and it's helpful for that aside, then I'm going to object to that. I don't want them, right? On the other hand, if the option is the witness coming in, and I'll let them testify I would agree to them testifying by Zoom because I think it's less effective. Now that there could be a cross point that I need to make, there could be some resistance to that, but it's certainly whatever the outcome is going to be that's best in the moment, for the case, right? I mean, that's the honest truth. There's really no principle behind it or guiding rule other than that.
How about an expert?
Well, I think experts are probably, similar. But it's hard to imagine a situation where, right, an expert is not, if it's been retained, is not going to come in and testify, right? And so, expert testimony is something that, cuts so many different ways in these trials, right? It's depending on the nature. It could be so important or it could be so unimportant. And so generally speaking, I think an expert testifying remotely is just fine. As most experts in our cases, right, are financial experts about some of the calculation of damages, of back pay and front pay and present valuing money and that sort of thing. And the less important that is, the less time it takes, the less anyone focuses on it. That's just better for the defense. A lot of times, if a plaintiff's expert says the damages are, 1.5 million, including front pay or something, and our expert says they're 800,000, we don't call our expert, right? Because we don't want the jury picky between those two numbers. We just want to attack the plaintiff's expert and then not talk about that issue anymore, right? And so that's the principle with experts, right? Especially that kind of expert. Just how can we minimize this as much as possible?
Judge Epstein, back in October, Judge McCauley, we did a zooming into the future webinar, and she told us that the Montgomery County Circuit Court judges are routinely allowing experts to testify now by Zoom because of cost and other considerations. Where do you come out on allowing experts to testify remotely in your courtroom?
The first question I have is there any objection, by the other side? And by and large, I don't get any pushback. The most frequent cases that we try are personal injury cases with relatively low stakes. And often in those cases, both sides, and the experts are doctors, and both sides have an incentive to minimize those costs and to agree to remote testimony. And I think that the kind of, the issue that Mr. Remy just described, if it's somebody on, testifying on present value, there's probably not going to be an expert on the other side. That's probably going to happen without any objection. And from the juror's point of view, the faster the expert's in and out, the better, the sooner they're out of their misery. But I would say, I don't know if Judge Irving has a different perspective. It really hasn't been much of an issue. I think we've had very few contested requests to have an expert testify remotely, or faculty, just for that matter.
Judge Irving, where do you come out on this?
I agree with Judge Epstein. I've not seen any dispute really over whether to allow anyone, fact or expert, to testify remotely. It's typically the parties come to an agreement, and I do not stand in the way of that agreement. If there is an objection, I did hold a hearing back in December. September. It was not a jury trial, but there were experts who were in Europe, and there was some contention over whether they should be allowed to testify, and I allowed the witnesses to testify. But typically, we do not see much disagreement over that.
If I could add, a lot of times the choice is not between having the witness testify live or remotely. The choice is between having a Dave Bennett essay deposition recorded a couple weeks before the trial versus remote testimony during the trial. And that, as the comments to the revised Rule 43 explained, was one of the driving factors. It makes a lot more sense basically to do a Dave Bennett essay deposition in real time during the trial.
Thank you. Judge Irving, I want to turn to motions in limine. What types of matters should be routinely addressed in motions in limine?
I would say generally almost any matter that has the effect of streamlining the trial. Typically, those motions are filed 3 weeks out. Some judges would prefer that they're filed a little longer than 3 weeks out before the pretrial conference. That gives the judge an opportunity to sit down and consider the motions and have a ruling by the time of the pretrial conference. But there are motions in limine limiting the number of fact and expert witnesses, or limiting the confines of the testimony to be expected. Evidentiary rulings are requested in those motions, and to the extent that and motions in limine are a good thing. It's a lot of work for the judge, but it certainly focuses the trial in such a way that makes the trial flow more efficiently and makes receipt of evidence more palatable to the jury. So I'm not sure what is not a typical or an appropriate request in such a motion, but we see all manner of motions attempting to limit what is presented at trial.
Thank you. Devin, what were some of the motions in limine that you faced in your most recent Superior Court trial?
We had a ton. It was a long summer of briefing. A big issue in our motions briefing were both the comparators as well as the Me Too witnesses that we wanted to present. With respect to the comparators, the university wanted to pare them down. Early on in the case, there had been a discovery ruling that we could get discovery on a pretty broad swath of professors at the university, younger applicants for tenure. We could get their tenure applications and compare their qualifications to those of our client. And so by the time we got to trial, we had about 25 or so comparators that we wanted to use, and the university was trying to limit those. Fortunately, we were able to present the comparators that we wanted to. But there was also another issue with the comparators, and that there was sort of two cohorts of tenure applicants that were at issue. The first group, like our client, had come up through the university's internal process. The other cohort were individuals who were laterally hired with tenure, and they tended to be more senior scholars who had already gotten tenure at another university. So we argued that that was sort of an apples and oranges comparison, and it was skewing the statistics higher to where the average age of a tenure grant was higher, because that latter group tended to be of an older age. We lost on that point, so we had to make that point to the jury. And then with respect to the Me Too witnesses, we had several other older women who'd been denied tenure by the same provost who we wanted to introduce to speak about their experiences. And we were fortunately able to present their testimony, but the court sort of split the baby on that issue, because those women had also filed charges or lawsuits against the university for age discrimination. And so that evidence was not permitted to be presented. It was too prejudicial, but we could put the witnesses on.
Thank you. Judge Epstein, I'd like to talk to you about trial bifurcation for a moment. You have never granted a motion to bifurcate trial on liability from the trial on damages. Why?
Well, for one reason, I can't recall any time that anybody's ever moved for that. I think the answer might be a little bit different in bench trials than in jury trials. I think, how to explain to a jury what to expect if you're going to have a trial on damages, how long is that going to take? I mean, lawyers sometimes get a little nervous about what incentives that might create into deliberations on liability. And usually the damages evidence is much, much more limited than the evidence on liability. You're not talking about a huge savings of time to bifurcate. A lot of times you have the same witnesses testifying about both liability and damages issues. So it would mean bringing witnesses back. It may end up being, more confusing, more time consuming, and not really shortening the trial appreciably. So I'd consider it, but it would be I wouldn't say a hard sell across the board, but I need to be persuaded.
Thank you. Judge Mize, I want to turn to jury selection for a moment and just talk about it kind of theoretically first. What is balanced judge-lawyer voir dire? And kind of what's the case for it?
Well, it's a partnership where you have the judge, the manager of the courtroom, wanting to make sure that no time is wasted, that at the same time the parties have adequate time to present their case. And I think experience tells me that some judges are more mindful of the number of cases on my docket. They affect how this individual trial works. Oh, I know when I was in the civil division, I don't know what the numbers are now, but if I was on a civil 2 calendar, there was maybe 300 or more cases on my docket. And we get notices at the end of every month, how many right motions are still pending. And you see what other judges are doing. And some can get, I got too many cases. I got to get this docket, my calendar reduced. So there are these time concerns. Others are not as much concerned about that, although concerned to some degree. Let's make sure we don't have to try this case twice. Let's make sure that whoever gets seated in the jury box and hears the evidence and renders a verdict is not going to be one with problems, with surprises that come up when a note comes during deliberations. One of our, and this has happened more than once in my connections with other courts, and somebody just doesn't talk during deliberations, is in a corner, won't speak, won't vote. We got to make sure that doesn't happen. And so I think jury selection is the underattended to part of trial by jury. It's not taught in law schools except a few. And so I think when you have a partnership with judge and lawyer, and research has shown that jurors are more likely to be candid in response to a lawyer question than a judge question. One reason being that the judge is up there elevated wearing the crazy robe, and this is I better say what that judge wants me to say, and that can inhibit candor. So and then our research has shown that around the country in most federal courts, and DC is a hybrid federal court, judges dominate, more likely than a judge is dominating voir dire. In the states around the country, it's more often that lawyers are dominating voir dire. Some jurisdictions, the judge is not in the courtroom when civil jury selection is underway. So, I mean, that's the other extreme, I think. And so, because lawyers know their case best and have an idea of what is important to find out so they can deselect certain people, and there's a warmth, a greater warmth toward lawyers, there's a benefit, more information comes out. And then some lawyers are over loquacious and start doing their opening statement during voir dire, and the manager of the courtroom has to bring that in. And judges, my experience is judges ask better questions than lawyers in terms of crispness, conciseness, getting the right answer, and leading the way with open-ended questions. And so there's that factor, and I'll stop there.
So was your practice when you're trying cases, you would ask questions of the venire yourself, but then you would take follow-up questions in the jury room rather than at the bench? Why?
Well, I started out as a trial judge in 1990, and the custom and practice in the court was after open court questions are asked, only those who had a yes answer to an open court question would come up to the bench for follow-up by both judge and lawyers. And the more I presided over jury trials, and more I conferred with other judges, both here and around the country, it became clear to me that there are people who are afraid to speak. There are citizens who don't want to answer a question standing up in a courtroom with 60, 70 other, well, in a civil case, maybe 30 other people in the courtroom, and to answer questions posed by the judge from the bench. There are shy people. There are people who are infected with there's a phrase, condition called social desirability effect, where they want to say what the judge wants them to say. So I decided maybe 3 years on the bench that I think I'd get more candid answers, and the lawyers would get more candid answers if we did it in the deliberation room. And so the way I set it up, the court reporter and I would be at the closest end of the table to the door. The parties on plaintiff defense on each side of the table. The juror comes in, there's a chair for her or him. They sit down next to me. I lead the asking for a greater explanation of why they had a yes answer to this, that, or the other. Or if they didn't have any yes answer to any question, did they understand the open court questions? Is there anything they'd like to revisit and say, now I have a yes to this that I said no to earlier? And I think in that room, it's more, it's not a courtroom. It's more like a table at some restaurant or something. It's got a different flavor to it. And so I am convinced, having done it both ways, that we had a more rich gathering of information in the deliberation room. And it didn't add much time because, thankfully, I've always had the cooperation of competent courtroom staff and law clerks. And as soon as a juror walked out of the deliberation room, having answered the questions, there was the next veneer member right outside the door that came right in. So the flow was, you didn't have to wait for somebody to come from the back of the gallery up to the bench. They were already there on the other side of the door. So it didn't really add time.
Judge Mize, what is a UFO juror?
That's a label I gave to the jurors in research I did some 12 or so years ago, where here again, I was thinking about, this is the way we always do it in this court. We judges are very happy when maybe 1/10 of the veneer panel have no yes answer to a question. Oh, great. We don't have to worry about them. They must be good. And I thought about that some more, and I did some research for 2 years, one on a felony calendar and the next year on a civil 2 calendar. And I brought everybody up to the bench, whether they had a yes answer or not. And I asked those who didn't have a yes answer, did you understand my question? Do you want to change your mind? And with the help of staff, I meticulously kept track of how many didn't have yes answers. And when there were significant changes and a no person a no answer person became a yes answer person, I carefully wrote down what they said. I carefully kept statistics. What percentage of the veneer had no yes answer in both of those years? And I published the research. And something like 21% of every veneer, on average, of a veneer, there were no yes answers. So that's 20% of UFOs. I'd bring them up and I'd ask the lead-in question. I kept track of how many of those new yes answers led to a agreed upon strike for cause. And it was a very high percentage. I can't remember off the top of my head. And, you would hear things like, in a criminal case, my brother overdosed. When I hear the word drugs, when I see this is a cocaine case, I get ill, I get nervous. I can't sit on this case. That was a no answer person in the open courtroom. Now we have that person here. Some people, you had a very heavy accent, and all of a sudden you realize this is not an English speaker, and they somehow got through all of the qualification process, and here they are in a jury selection. The coup d'état that came out in the felony year was, a young lady came up. I asked her, did you have any yes answers? She says, Judge, I really should have answered yes, because the defendant is my fiance. Well, when I published the research, now Senior Judge Bob Richter sent an email to all of us, and he said, you know, if we don't ask every single juror whether they have a yes or no answer to the open court question, if we don't ask them some questions, that would be judicial malpractice. And I think that, you know, Bob's statement had an effect, and I have a hunch that most judges do ask everyone to come up for follow-up. And it's growing around the country, that practice. I think largely because of some research that has been done on it.
Judge Mize, thank you. Let's turn to jury instructions. Judge Epstein, what should counsel consider when crafting non-standard jury instructions?
Well, both sides are entitled to instruction about their theory of the case. If the standard instructions don't cover that, they're entitled to an instruction. You know, it needs to be balanced. It shouldn't be one-sided. You know, we don't get very many requests for those. You know, and some that we've gotten on a more regular basis, we've now integrated into the Red Book, the book of standardized. I'm sorry, the blue book. The Red Book is criminal cases. Blue Book is civil cases. You know, my view is, I mean, the shorter the instructions are, the better. I think it's much more useful to jury to hear argument from lawyers than to listen to a judge drone on. And I admit, I drone. I try to modulate my voice and do all the right things, but you know, and I think all of the judges give jurors written copies of the instructions, so they'll have those to refer to. But there's some gaps in the standardized instructions, and if those need to be filled in, jurors should come up. You know, there are some other jurisdictions of good instructions on some issues, and you know, I'm always happy to borrow from them, other jurisdictions, and learn from them.
Judge Irving, if the parties come to you with agreed instructions, let's say in an employment case as an example, will you defer to the parties?
With an agreed upon instruction? Yes. Well, I want to make certain that the instruction is relevant to the case, but when both sides have agreed upon an instruction, I read it to the jury.
Thank you. Devin, let's talk about verdict sheets for a minute. What's your general approach to the preparation of your verdict form?
I think the goal there should be keep it simple and to try to mirror the language of the jury instructions as best as you possibly can. On our end, we don't want to give the defense any opportunity to argue that the jury was confused by the verdict form. So in our tenure trial, we asked for a pretty simple yes or no on liability for each claim using the jury instruction language that we had proposed. And then we tried to break the damages down into different categories. And it's funny, actually, I was looking back at that verdict form yesterday, and I remembered something. We had a sort of an interesting tidbit from the jury on the form. So we lost on breach and we won on age, which we were sort of surprised by because we thought the breach claim was very strong. But the DC instructions on breach that the court issued instructed the jury that they had to determine whether the university substantially complied with its own procedures, which is not the language that we wanted, but it was a standard instruction, and that's what we got. So the court used that language in the verdict form too, and the jury put a handwritten bracket around that phrase, substantially complied. So I think they were trying to signal that language sort of influenced their decision, meaning that maybe they did not think the university fully complied, but they did find substantial compliance, which we found interesting. But again, I think in general, sticking to the language of the instructions, unless those instructions are particularly unhelpful, is the safest approach.
Thank you. Juror questionnaires. Judge Irving, you'll allow the parties to use a questionnaire if the parties agree on one in advance. Is that right?
I'm not sure about that. To the extent that at the pretrial conference, and backtrack to the joint pretrial statement, we've looked at the questions that the parties wish to be read. We're talking about the instructions now.
So forgive me. So let's just say that the parties want to issue a juror questionnaire before the jurors walk into the courtroom. Let's say on particular topics that are relevant to their case. Will you allow that questionnaire?
I've never had the opportunity. No one's ever requested use of a questionnaire, and it's never come to my attention.
If they were to ask you to use a questionnaire, would you be willing to consider it?
Not on the civil side. Typically, we've already determined what questions will be asked of the jury. They're typically 12 to 15 questions. If the case is much more complex, a few more questions. But those are the questions that I will ask of the jury. And I've never used a questionnaire, and no one's ever requested, and I'm not quite certain how it would work on the civil side. I believe questionnaires are used on the criminal side. Judge Epstein likely has a bit more experience with.
I think we've used questionnaires on the criminal side in a handful of cases, generally involving a lot of publicity, where there's been jurors summoned essentially for a particular trial. On the civil side, we don't, summon jurors for specific trials. The jurors who get summoned could be in any civil trial scheduled for the day. They could be in any criminal trial scheduled for the day. There's not much of an opportunity between the time the list of jurors that are sent to the civil courtroom are identified and the time they show up in the courtroom to administer the questionnaire. And a lot of the questions you can cover orally anyway.
Thank you. Let's turn to demonstrative exhibits. Judge Irving, when should demonstrative exhibits be exchanged in the run of the trial?
I'm not sure that there's a hard and fast rule. My preference is that with respect to all exhibits, that they are exchanged 2 to 3 weeks out from the pretrial conference. But certainly the exhibits to be used at trial should be identified and labeled by the pretrial conference. I have had trials, though, where demonstrative exhibits have been prepared the night before, and the parties argue over them at some point during the trial. I've not really required that those exhibits be exchanged 2 to 3 weeks out.
Judge Epstein, are demonstrative exhibits, from your vantage point, useful tools in the lawyer's toolbox at trial?
When you use that term, do you mean exhibits that are not admitted into evidence?
Yes.
Yes, they are. And if anything, I'm disappointed that lawyers don't do more of that. I don't think lawyers take advantage of PowerPoint and similar technologies and opening statements and closing arguments. The old saying is true: a picture is often worth 1,000 words, and it's a lot helpful. For some things, they can and should be discussed before trial. So there's no objection. Goes back to Mr. Remy's point. You don't want to talk about something in your opening that turns out you're not going to be able to use during the trial. But sometimes some things are a lot easier to explain with a demonstrative exhibit than they are with words.
So Devin, you used some demonstrative exhibits during your recent trial. Tell us a little bit about what you used, and were they on poster boards, video technology? How did that work?
We put them straight onto the court's projector technology that was available to us. And we used a number of different demonstratives. I'll give you a couple examples. One of them was focused on trying to make the different stages of the tenure process more clear to the jury, because it's sort of a convoluted process. So we had a chart with the 6 different levels of review, and we put these green check marks next to the 5 levels of review who had given positive evaluations to our client. And then we put this big red X next to the last level, which was the provost review where he denied tenure. So that was sort of a visual, what happened there? Why is the last one the red X? I thought that was a pretty good visual for the jury. And I think that could probably be applied to other types of employment review processes. We also had a chart that listed out our comparators. So the younger applicants who did get tenure, and there was a lot of different information about their history in academia and their publications and things like that we synthesized down into these charts with different numbers for their publications and citations and things like that. And I think that helped show how our client was as or very much more qualified than those comparators. And then the last one that I thought was pretty helpful was a blow up chart of the economic damages that our expert had calculated. And he'd calculated them out by each year, the front pay out by each year through retirement age. And we were sort of surprised by this, but the judge allowed the jurors to take that chart actually back with them as they were deliberating. And their verdict did reflect the calculations. I think having those concrete numbers to work with probably helped in reaching a decision, and also maybe to reach a compromise on the number that they came up with, because they didn't choose the highest calculation through, age 72, but they did land close enough to it. And that was great for us. So I think a chart like that can be very effective on top of the expert testimony itself, especially if the trial judge will let the jurors take it back with them.
Devin, thank you. John, let's talk about opening statement from the defense perspective for a moment. What are the critical things that you want to get across to jurors in opening statement?
It's similar to the point I made earlier about the plaintiff going first, right? And you having to play catch up. Well, that's also true for the opening statement. Most of the time you stand up and look on some jurors' faces. Well, what is this guy going to say now, given how bad his side is and how obvious this case is for the plaintiff, right? After hearing plaintiff's counsel. So the first thing, it's a win if you get back to neutral, right? You would take that in most of the time. Just get it back to, all right, well, both sides have something to say. We're not going to make a decision right now, right? Based on the openings. So that's figuring out how to do that, and getting their attention and getting them to trust you a little bit. I guess that's really the second big point is trust. A lot of it is, if we talk about, do you believe the witnesses and who's trustworthy? A lot of that is on counsel too, right? Do the jurors believe the lawyers? And so I look for ways to seem reasonable, seem believable, seem trustworthy, and then to let them test that trust. I welcome them testing that trust, right? Like, I'm going to show you this, I'm going to show you that. Like, I want to be able to them to count on it. And then I want to do the exact opposite thing to plaintiff's counsel. I listen for that opening. Of course, you have to, you change your opening a little bit based on every single time, based on what the plaintiff's counsel says. But I really look for things that they say that I think are not going to be borne out, even relatively minor ones. And I point them out to the jury, and I don't promise it. I don't say that's never happening. I say, Mr. Oswald just told you, boom, 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 right? I want you to remember that. I want you to remember that he said that and see if that actually happens in this case. Do not forget that he said that, which also is a little bit of a dramatic sort of flair to it, right? And it makes them all of a sudden think, well, maybe he's not telling me everything, the truth there in that opening. So those are kind of, I'd obviously you want to lay a roadmap for your case and all the standard things and openings.
So one of the things that you talk about with the jury is, why would the company do that?
Yeah.
Give us an example.
Well, I mean, this happens, it happens all the time. Hiring somebody, it's so expensive for a company to terminate an employee that they put all this effort into, and then go find a replacement who may or may not work out, train that person. That is no decent, rational business would do that if they could avoid it. And so that that's just one example of why would a company, or why would an individual, why would they do what the plaintiff is alleging they did? Why would they? Now, this is by the way, one of the things that's hard about retaliation cases, because there's an answer in the retaliation case to why would they do that, right? Because the person started complaining, and that's something that you don't like. That's one of the reasons retaliation cases are harder. But in your average discrimination case, someone's been there for a while, and why would this company put themselves in this situation, right? If it was a choice they were making for some non-business related issue. I think it's a pretty powerful point a lot of the times, especially if you've got business people on the jury.
Thank you. Devin, looking back on your most recent jury trial, what did you do right?
I think we did, well, we won, so I think we did a few things right. I think we did really well with the comparator evidence that we had, just synthesizing a lot of complicated information about people's criteria for tenure and qualifications and history and academia and all of that into these visual aids for the jury to really see the difference in treatment between our client and some of these younger applicants. I also think we did very well with impeachment, which gave us a lot of credibility, or alternatively did not give the defendant any credibility. We sort of had 3 bites at the apple with 2 of the main bad actors, because we'd already deposed them once in our case and twice in a companion case that had resolved before this trial. So we were able to use some of that testimony to impeach the university president several times, which I think landed well with the jury. And then the last thing I would say is I thought we did a pretty good job of coming off more sympathetically, both as client, but also as counsel. I think defense counsel was pretty aggressive in their objections and in examining our client and other witnesses and even witnesses who worked for the university. I mean, it was pretty aggressive questioning. So I don't think that did the defendant any favors. And I think it's important to remember that the jury is not only making judgments about the parties, but also about the lawyers who represent those parties.
What would you do differently?
I would try to simplify even more. I think we did our best, but I would have tried to eliminate even more of the exhibits as that can get kind of clunky while you're doing examinations. We gave the jury a lot of paper to take back with them, which could have been overwhelming. I think the jury is probably less likely to actually read the documentary exhibits if there's stacks and stacks of them as opposed to a smaller pile that seems a little more digestible.
So John, let's talk about, you've been doing this a while, right? You've had a lot of jury trials. What advice do you give to newer associates in your firm when they're trying their first jury trial?
Yeah, so this is going to sound not like it's very much news, right? But you have to be incredibly prepared. You have to know that case as if you were living it at the moment, maybe twice, so you went through it yourself. And at the same time, right? So being prepared, that lets you react. All right. When you know everything that on your side, these documents are like you wrote them, then that lets you pivot, because that's something happens during every trial, at least every trial I've had, that you don't expect. And often it can be determinative or largely determinative, and no one knew it was going to happen, right? You had to make a decision, a snap decision. But the other thing is that if you don't enjoy these trials, you're in the wrong business. I mean, that's the ultimate thing we do. You can't be a defense lawyer and hope to win summary judgment or settle every case. Like, that's taking that really is not good for your clients if you're afraid to try cases. You have to be willing to do it, and I think you have to enjoy it. And so, my mentor in this process was extremely focused, but also very relaxed and enjoyed it and had a degree of casualness about him during these trials, even though he was, incredibly successful and up all night kind of guy. And I think that you got to bring some of that to it, right? So I think you have to enjoy yourself.
We are ready for final thoughts. Devin, why don't you start us off? Final thoughts.
Well, to echo a little bit of what John just said, my best advice as you're preparing for a trial is to do a lot of prep and to start prepping early. I found it very helpful to make a written schedule with benchmarkers, especially for that 90-day lead up to trial, things you want to accomplish by this week and this week. And it's so easy to fall behind in the trial prep with all of the work that starts to build up and the motions that are getting filed. But if you set internal deadlines for yourself, you can keep yourself accountable to those deadlines, and that can help keep you on pace. And I think for plaintiffs' lawyers especially, sometimes we can start to feel a little out-resourced by the other side, but we can certainly out-prepare the other side if you put in the time. So that's my 2 cents.
Devin, thank you. John?
Well, my advice is that it's really stressful, but that's a good thing, right? You should, I guess the expression is lean into it, right? Waking up at 4 o'clock in the morning, 5 days before your trial, improving or going over your opening or some direct is not something that you should say that you should try not to do. And it's not something that you should be upset about that's happening, right? That's not the time of your life to be like, oh, I shouldn't let my work interfere with that's right. That's not the time for that. Part of enjoying it is just like really leaning into that, and that's going to produce the best results.
John, thank you. Judge Irving, final thoughts.
I would echo what Ms. Wrigley mentioned a few moments ago, is to simplify, simplify, simplify. I typically say during my pretrial conferences, I remind, or at least alert the attorneys that I've been a juror 5 or 6 times here at Superior Court. So I have seen lawyers from that perspective. Aggressive behavior is offensive. Be strategic about objections. You really do not have to object to every question. And be strategic even about the duration of cross-examinations. I was taught at DOJ that sometimes it's powerful not to cross-examine a witness at all, but risky. But so I would keep those things in mind.
Thank you. Judge Mize, final thoughts.
I'm very impressed with our practitioners, John and Devin. And if all lawyers were like you all, then maybe I would have a little warmth toward letting the lawyers do all the questioning. I'm very impressed, and I'll stop right there.
Thank you. Judge Epstein, you get our last word. Final thoughts.
I've talked to most jurors, certainly on the civil side, and my faith in the jury system has increased. I think the jurors we get are thoughtful, focused, attentive. I think because of the measures Judge Mize talked about, we really got a cross-section of the community. And when you get 6, 8 people who don't know each other trying to figure out what happened and why, I think jurors generally get it right. Ms. Wrigley talked about accountability. I think the jury system provides real accountability. And one thing it does is put a premium on lawyers to really realistically, objectively assess their case and decide if this is a case they want to try or not.
Thank you. Thank you, Judges Anthony Epstein, Alfred, Irving, Gregory Mize. Thanks to John Remy, and a special thanks to Devin Wrigley, who organized this webinar for us. And a final thanks to Rawle Andrews, President of the Bar Association of Montgomery County, who joined us to tell us about the BADC. For future programming from the Metropolitan Washington Employment Lawyers Association, you can find us at www.mwela.org. Thanks for joining us today.